Donald Trump's strongest defenders are now his greatest legal threats. His inner circle is actively flipping, choosing self-preservation over loyalty, and bringing his defense strategy to its knees.
Two former lawyers for Donald Trump in the spotlight tonight. One, the latest co-defendant to plead guilty in the election interference case against the Republican frontrunner. The other, a star prosecution witness at his fraud trial in New York. Laura Jarrett has late details.
For weeks, attorney Jenna Ellis fiercely defended then-President Trump as he falsely claimed the 2020 election was rigged. Today, she sobbed as she told a judge she was wrong.
If I knew then what I know now, I would have declined to represent Donald Trump in these post-election challenges.
Ellis in a Georgia courtroom pleading guilty to a felony for helping fuel lies about thousands of dead people casting votes in 2020.
I failed to do my due diligence.
Smiling for her mugshot just 2 months ago, now the fourth co-defendant to flip in Fulton County's sprawling election interference case against the former president and more than a dozen others. Mr. Trump has pleaded not guilty, arguing he's being targeted by Democratic prosecutors because he's the Republican frontrunner. He was back in a Manhattan courtroom today, facing the state's star witness, his former fixer turned foe, Michael Cohen.
This is about accountability, plain and simple.
Raise your right hand.
It was Cohen's congressional testimony that jump-started the New York case, where his former boss now stands to lose his namesake company, accused of exaggerating the value of his assets to receive better loan terms in a $250 million civil fraud suit.
It was my experience that Mr. Trump inflated his total assets when it served his purposes.
Today, Cohen said he was tasked by the former president with boosting Mr. Trump's total assets to achieve a number he arbitrarily elected. While Mr. Trump's legal team has argued real estate values are subjective. Outside of court, Mr. Trump took aim at Cohen's credibility, pointing to Cohen's guilty plea for tax fraud and lying to Congress.
Well, he was a proven liar, as you know, a felon. So he's a liar, trying to get a better deal for himself, but it's not going to work. We did nothing wrong, and that's been proven.
And Laura is here. Michael Cohen will be back on the stand again tomorrow.
Yes, he will face more cross-examination by Mr. Trump's legal team tomorrow as they're trying to show the judge why he simply shouldn't be trusted given things that he said in the past. Mr. Trump also expected back in court tomorrow. They were seated just feet from each other today.
Former Trump legal advisor Jenna Ellis is taking a plea deal in connection with the election interference investigation out of Georgia. She's pleading out to one charge of aiding and abetting false statements and writings. And moments ago, she addressed the court. Let's play that.
Thank you, Your Honor, for the opportunity to address the court. As an attorney who is also a Christian, I take my responsibilities as a lawyer very seriously, and I endeavor to be a person of sound moral and ethical character in all of my dealings. In the wake of the 2020 presidential election, I believed that challenging the results on behalf of President Trump should be pursued in a just and legal way. I endeavored to represent my client to the best of my ability. I relied on others, including lawyers with many more years of experience than I, to provide me with true and reliable information, especially since my role involved speaking to the media and to legislators in various states. What I did not do, but should have done, Your Honor, was to make sure that the facts the other lawyers alleged to be true were in fact true. In the frenetic pace of attempting to raise challenges to the election in several states, including Georgia, I failed to do my due diligence. I believe in and I value election integrity. If I knew then what I know, I would have declined to represent Donald Trump in these post-election challenges. I look back on this whole experience with deep remorse. For those failures of mine, Your Honor, I have taken responsibility already before the Colorado bar who censured me, and I now take responsibility before this court and apologize to the people of Georgia.
All right. So joining us now with more analysis is CBS News legal contributor Jessica Levinson. I mean, I don't know if I've heard anyone kind of openly say, I made a mistake. Anyone who's sort of been caught up in this Donald Trump stuff. And she mentioned being censured in Colorado. She was, and that was for essentially lying on, she was on Newsmax. She said that, that Nevada, Michigan, Pennsylvania, Wisconsin, and Georgia combined, that we know that the election was stolen from President Trump, and we can prove that. And there were countless lawsuits, and none of that was ever proven. And obviously in Colorado, they concluded that she knew better. there. So what's your reaction to the plea deal?
My reaction is that this is fairly typical. We have now in short order seen 3 of the former president's former attorneys plead guilty, and there's no motivation to accepting a plea deal like looking to the left side, looking to the right side, and seeing that people you worked with are now taking these deals. I think ultimately this is not good for the former president. I think Trump, one, wanted to be able to rely on a defense called assistance of counsel. And when you have 3 of your counsels pleading guilty to criminal violations, that becomes more complicated, to say the least. 2, I think Trump wanted a preview of Fani Willis's cases. And now that these plea deals are happening, these cases won't go to trial. He won't see that preview. And so I think that this is good news for the prosecution, and it has to feel rather ominous for the former president.
As we mentioned, this comes just days after the other 2 guilty pleas entered in by attorney Sidney Powell Kenneth Chesebro. Let's talk about the value of that testimony and what they might say. What kind of context, what kind of impact will that have on this?
Right now, 2 former lawyers for Donald Trump are commanding the public spotlight. One has recently pleaded guilty in the sweeping election interference case taking place in Georgia, while the other serves as the prosecution's star witness in a high-stakes civil fraud trial in New York. For weeks, attorney Jenna Ellis fiercely defended the former president as he continually broadcasted false claims that the 2020 election was rigged. Yet, the atmosphere shifted drastically when she stood in a Georgia courtroom. Through tears, she explicitly admitted to the judge that she was wrong, stating that if she had known then what she knows today, she would have absolutely declined to represent Donald Trump in his post-election legal challenges. Ellis pleaded guilty to a felony charge related to aiding and abetting false statements, specifically acknowledging her role in fueling widespread lies regarding thousands of deceased individuals casting ballots in 2020. She confessed to failing her due diligence, presenting a stark contrast to the woman who was smiling in her mugshot just 2 months prior. She represents the 4th co-defendant to cooperate in Fulton County's expansive election interference indictment against the former president and over a dozen associates. Mr. Trump has maintained a plea of not guilty, asserting that he is being unfairly targeted by Democratic prosecutors simply because he is the Republican frontrunner. Meanwhile, he recently found himself back in a Manhattan courtroom, directly facing his former personal fixer-turned-adversary, Michael Cohen. This situation is fundamentally about accountability, plain and simple. The former president's inner circle is rapidly disintegrating as the very lawyers, advisors, and loyalists he trusted are now securing plea deals and preparing to offer testimonies against him. They are opting for self-preservation over a sense of loyalty that they realize would never be reciprocated. The absolute fealty upon which Trump built his entire operation is crumbling in courtrooms nationwide in real time. This cascading betrayal encompasses several of the most prominent figures from his post-2020 legal operation. Sidney Powell, once among the fiercest and most vocal advocates of the election fraud conspiracy theories, has officially pleaded guilty to conspiracy charges. She admitted to participating in efforts to tamper with voting equipment in Georgia. Her cooperation is incredibly damaging because she was present in the pivotal meetings. She knows exactly what Trump articulated, what he directed, and the intimate details of both the pressure campaigns and the alternative elector scheme. She has now formally agreed to provide truthful testimony concerning all of these events. In New York, it was Michael Cohen's congressional testimony that originally ignited the investigation threatening the former president's namesake company. Trump currently stands accused of artificially inflating his asset values to secure highly favorable loan terms within a $250 million civil fraud lawsuit. Cohen testified that, based on his direct experience, Trump routinely inflated his total assets to align with whatever arbitrary number he desired at the time. While Trump's legal defense team insists that real estate valuations are inherently subjective outside of court, Trump himself has publicly attacked Cohen's credibility. He continually highlights Cohen's prior guilty pleas for tax fraud and lying to Congress, labeling him a proven felon and a liar who is merely seeking a better deal for himself, However, Cohen is slated to return to the stand to face intense cross-examination from Trump's team, who aim to convince the judge that Cohen is entirely untrustworthy based on his past misdeeds. The situation in Georgia is equally perilous. Jenna Ellis, who frequented television networks to repeatedly disseminate election fraud claims, has officially admitted to spreading false information. She has agreed to testify against the remaining defendants, a group that unquestionably includes Donald Trump. Her capitulation is uniquely destructive due to the existence of leaked proffer videos. In these recordings, Ellis vividly details how the former president steadfastly refused to accept the election outcome and remained entirely determined to hold on to power under any circumstances. Joining this wave of cooperation is Kenneth Chesebro, the legal architect who actually drafted the comprehensive fake elector strategy and authored the legal memorandums outlining its implementation. Chesebro was intimately involved in coordinating the submission of fabricated elector certificates across multiple states. Because he possesses granular knowledge regarding how this scheme was structured and who participated at every operational tier, he is currently guiding prosecutors through every single facet of the conspiracy. It is vital to recognize that these individuals are not peripheral figures or low-level staffers. When addressing the court regarding her plea deal for aiding and abetting false statements, Jenna Ellis emphasized her background as a Christian and a lawyer. She claimed to take her responsibility seriously and strive for moral and ethical soundness. She explained that in the chaotic aftermath of the 2020 election, she genuinely believed in pursuing legal challenges on Trump's behalf. She admitted to relying on attorneys with far more experience to supply her with accurate information, particularly given her role as a media surrogate and legislative liaison across various states. Yet, she acknowledged her critical failure to verify the facts provided to her during the frenetic effort to contest the election across states like Georgia. Expressing profound remorse and highlighting her prior censure by the Colorado bar for making unsubstantiated claims on television, she formally apologized to the citizens of Georgia. The legal implications of these shifting allegiances are completely devastating for the former president. Trump's core defense strategy heavily relied on the premise that he was merely following the advice of his legal counsel, completely unaware that the proposed actions were unlawful. This advice of counsel defense entirely disintegrates when the very attorneys providing that advice openly testify that he personally directed them to commit these offenses. Furthermore, the public broadcast of this betrayal through leaked proffer videos and open court testimonies ensures the American populace witnesses Trump's own personnel, detailing his efforts to pressure them into criminal acts and his outright refusal to vacate the White House. This is not opposition research or media spin. This is unvarnished testimony from Trump's hand-picked loyalists describing his conduct in their own words. Compounding the substantive legal threat is the chaotic atmosphere surrounding Trump's defense efforts. During the New York trial, a defense witness named Robert Costello repeatedly clashed with the presiding judge. Costello exhibited highly unprofessional behavior, making side comments, rolling his eyes, and muttering under his breath at judicial rulings, which ultimately forced the judge to dramatically clear the courtroom. Such dysfunction paints the defense as disorganized and profoundly desperate, precisely the opposite image a legal team wishes to project to a jury. Jurors are inherently influenced by professionalism, and witnessing a defense team spiraling into disrespect fundamentally undermines their credibility, irrespective of the case's core merits. This pattern extends to Georgia, where judges have frequently categorized the defense's legal motions as entirely meritless and frivolous, seemingly designed solely to delay the proceedings rather than present a legitimate argument. Meanwhile, Michael Cohen's testimony in the New York hush money trial provided devastating first-hand insights. As an individual present for the most sensitive and confidential conversations, Cohen explicitly testified that Trump personally directed the hush money payments and approved the complex reimbursement schemes. He recounted how Trump was entirely obsessed with suppressing the Stormy Daniels narrative prior to the election. For a jury, intimate testimony from a participant with direct, foundational knowledge is overwhelmingly persuasive. Prosecutors strategically rely on a cascading effect to dismantle large-scale conspiracies. When one co-conspirator flips, it triggers a chain reaction. Former allies quickly realized that unwavering loyalty to Donald Trump yields no protection. The only viable method to mitigate their own criminal exposure is to cooperate with authorities. Consequently, an increasing number of former advisors and attorneys are securing deals, systematically weakening Trump's defensive posture and exponentially increasing the pressure on remaining holdouts. In the sprawling Georgia case, this dynamic is exceptionally lethal. Sidney Powell's cooperation weaponizes her as a witness against the entire operation. Jenna Ellis supplies vital corroborating testimony regarding the actions of her co-conspirators, while Kenneth Chesebro maps out the intricate architecture of the fake elector plot. Instead of facing a unified defense, Trump is confronting an array of witnesses whose independent testimonies continuously reinforce and corroborate one another. This widespread pattern of defection is not isolated to Georgia. In New York, Cohen's cooperation previously yielded a conviction on 34 felony counts. In the classified documents investigation, insiders at Mar-a-Lago have flipped to expose plots aimed at deleting critical surveillance footage. In the federal election interference case in Washington, D.C., multiple advisors have aligned with the special counsel. The cumulative magnitude of this cooperation creates an insurmountable legal nightmare. It is crucial to understand the foundational reality of the justice system. Prosecutors absolutely do not extend cooperation agreements unless they possess overwhelming evidence of guilt and are entirely confident in their ability to secure convictions at trial. The sheer volume of cooperators explicitly indicates that the evidentiary record against the former president is exceptionally robust. The political fallout mirrors the legal catastrophe. Every instance of a former ally detailing his transgressions slightly erodes his broader political support. Every video showcasing an attorney describing his unconstitutional ambition turns more voters away. As Michael Cohen outlined the direct orchestration of the hush money cover-up, the American public gained a clearer understanding of the actual legal violations committed. This scenario is not a manufactured political persecution. It represents a systematic pursuit of accountability. Trump is visibly losing control of a narrative he historically dominated. He possesses no ability to dictate courtroom testimonies or manipulate sworn statements. Being forced to sit silently while his former subordinates outline his criminal conduct generates profound frustration, projecting an image of increasing desperation and instability. The authenticity of the leaked proffer videos renders them virtually impossible to politically neutralize. The footage is devoid of media spin or prosecutorial editing. It features Trump's own legal representation freely discussing how he pressured them into illicit actions and sought to circumvent the democratic process. As the public observes these events unfold in real time, they are actively concluding that Trump is a perpetrator who actively sought to subvert a legitimate election rather than a victim of a targeted witch hunt. The stark divergence between his social media declarations of absolute victory and the grim reality of his loyalists pleading guilty in court is rapidly widening, and the electorate is acutely aware of this disparity. Beyond immediate political and legal ramifications, these proceedings are fundamentally testing the resilience of the rule of law. If individuals wielding immense power can orchestrate criminal conspiracies without facing consequences, the entire democratic architecture is critically undermined. Conversely, imposing accountability upon such figures inherently fortifies the system, demonstrating unequivocally that no citizen, including a former president, operates above the law. The specific offenses being admitted to are not mere administrative errors. They are grave infractions. Conspiracy to interfere with election protocols, tampering with voting machinery, manufacturing fraudulent documentation, and obstructing justice represent calculated strikes against the very heart of democratic governance. Trump's typical strategy of aggressive defiance, attacking the judiciary, insulting prosecutors, and branding the proceedings as a rigged witch hunt is rapidly losing its efficacy. The narrative of external persecution rings entirely hollow when the individuals confessing to the crimes and pointing the finger at him are his own hand-selected attorneys and advisors. The timing further exacerbates his predicament. He cannot passively wait out the judicial clock or vaguely promise future vindication. He must confront these compounding crises immediately under the intense scrutiny of the American public. The avalanche of corroborating evidence, documents, and insider perspectives severely constricts his ability to claim that the entire world is lying while he alone tells the truth. The international community is also closely monitoring this unprecedented legal reckoning. Allies and adversaries alike are observing whether the United States possesses the institutional fortitude to hold a former president accountable for attempting to subvert an election. This process sends a resolute message regarding the durability of American democratic institutions and significantly impacts the nation's standing on the global stage. Ultimately, Donald Trump's defensive perimeter is rapidly collapsing. As the trials progress, more witnesses will likely defect, additional devastating testimony will emerge, and convictions appear increasingly probable. There is no conceivable legal maneuver capable of neutralizing the sheer volume of this compiled evidence. His associates have rationally calculated the catastrophic risks of prison against the hollow rewards of loyalty, decisively choosing to tell the truth and save themselves. The most striking aspect of this entire ordeal is that it was entirely self-inflicted. He had the opportunity to graciously accept the election results and peacefully transition out of power. Instead, he chose a path of illicit schemes, intense pressure campaigns, and the mishandling of classified materials. Today, he is finally confronting the severe consequences of those deliberate choices. As his inner circle continually chooses self-preservation over allegiance, the walls are closing in completely, leaving him with no viable escape strategy from the overwhelming weight of accountability.